ready, please. Thank you.
Court rise and able.
Mr. Turner. My Lords, I come to these key headline observations. The attempt here is to try to distinguish the wood from the trees and to take an overview and to see the gist of the case and what the key issues for the court will be. My first observation concerns my learned friend's approach to dissecting the judgment below, which occupied a large part of his address on Tuesday. He referred to a number of issues that I will have to deal with, including a key proposition that the judge didn't understand what unpacking a lump sum license involved, and that in the words of paragraph 80 of their skeleton, the judge viewed unpacking itself as impermissible, which is what led him to work in the currency of lump sum amounts. However, my friend's general technique was to work, using his words, at a lick, through a great assortment of intricate points in the judgment, where it was said the judge had got muddled. That was a word used 22 times on Tuesday, or where the judge had used phraseology that was hard to understand. It was also repeatedly said that the judge defied what was common ground. This is forensically understandable and was skillfully done. It's intended to convey to the court the impression that the judge in general made a Horlicks of it and wasn't competent. And as I said before lunch, I don't shrink from the proposition that the judge occasionally in this judgment made statements that are hard to reconcile with other statements in the same document. And I will indeed be referring to a few of them myself. But I would caution this court against reading the judgment as if it were a statute. And my submission is that where it matters for the appeal, Mr. Speck's points were overheated and they were incorrect. For example, it's true that the judge's phraseology was imperfect in a number of places that Mr. Speck pointed to. Our submission is that in context, you have to read the surrounding paragraphs, the meaning is clear. And I'd like to take the example that Mr. Speck underlined, where the judge refers to there being insurmountable difficulties, you recall, in addressing three subjectivities when you're analysing licence deals. Mr. Speck said on Tuesday, and this is from the transcript, this is the real issue that causes him to reject everything they have done. It is the wrong word. As my Lord Justice Arnold pointed out, something is insurmountable if there is no solution. And yet, as Mr. Speck also rightly said and told you yesterday, the judge goes on himself to address the very same issues. Now, if you read this phrase in the context of the surrounding paragraphs, you see that the judge should have used a different word. He should have said that it was unavoidable or inevitable. The judge's real meaning, most particularly, was that when you're deciding how to analyse these comparable licences in a Frand case, you do need to square up to the question what rate structure to adopt.
Yes, but of course, if the difficulties were unavoidable, the experts couldn't possibly be criticised, and therefore he should have proceeded on the basis that they did.
Well, let me come in a moment, my Lord, to what he does say about the experts on that very point. But if I may, I'll just introduce it, because this is a major point in the case. Below, between the parties at the trial, the case for Optis was they were advocating an ad valorem approach to a patent licence for Apple, in line with the comparables that they were presenting. Apple was opposing it. The judge said, I want assistance. He recognises that Apple, in this respect, when you're talking about ad valorem rates because of its particular commercial features, is an unusual industry player. His frustration was that he didn't get the assistance that he wanted to help him decide, for example, that important question, either from the parties or from their accountancy experts. And then if we can turn to it, you go to in the judgment to page 393 in Call 1. And turn to tackle the point. Paragraph 314 is at the top, second paragraph down. And if you substitute the word unavoidable, what was in my judgment an unavoidable difficulty was how I've termed the three subjectivities were to be resolved. And the first of those is the rate structure, if you go back. Inevitably, they would have to have been resolved by the exercise of judgment, which of them's right for this case. And had the valuation experts attempted to do so, no doubt they could have been accused of seeking to give the court the final answer to the Fran question, something experts are rightly told to avoid. And I pause there because, for my part, I also find that slightly difficult to take on board, because he then goes on to say that it's something that he would have expected the experts to do. He says, instead of doing so, the experts unpacked in accordance with the instructions of their clients. Roman 1 is Mr. Besant, who was Optis. He was instructed as to the way he should approach valuation. And you see from the last sentence there, the ad valorem approach, as opposed to the lump sum approach, is of course Optis's case as to how the Fran rates are to be found. But that approach must be justified, not simply assumed or followed without question. So you see the nature of his concern coming out. And Miss Gutteridge was similarly instructed as to her approach, which was to take as the foundation for her approach the lump sums in the Apple contract.
Just pausing there, the specific point is Mr. Besant unpacked lump sum royalties into ad valorem royalties without doing the reverse. Well, so converting ad valorem royalties into lump sum royalties. Well, nobody was contending for lump sum royalties, were they?
No. What we see is going on here, and Mr. Speck was again right to refer to his use of lump sum rates. When he's using that expression, he does appear, in many cases, really to be referring to the dollar per unit rates, which was the alternative way in which the Apple case was presented.
Is that right?
Not consistently.
When the judge says that Mr. Besant unpacked lump sum royalties into ad valorem royalties,
yes.
You know what Mr. Besant did. What was he unpacking into ad valorem royalties?
Well, the Optis licenses, save for one, and I'm pretty sure that's not confidential, which one it is, isn't it? Yes, good. Apart from Google, those were already on an ad valorem basis.
Yes.
So Optis has essentially obtained a percentage of the selling price of the handsets from the counterparties. The Apple licenses, when he turns to those, which he does as part of a responsive case, he again approaches in the ad valorem sense in terms of breaking it down.
And those are lump sums?
They were lump sums, yes.
So
the Apple ones come as essentially in return for a patent license for X years.
Lump sum.
It's a lump sum.
On the face of it, what he's referring to is converting lump sums into royalties. So when the judge complains that he didn't convert royalties into lump sum royalties, he presumably means converting royalties into lump sums. Well, that's not what anybody was suggesting.
No,
I understand it.
No, that's right. And again, I'm not defending that specific terminology. There was a distinct purpose to what he was asking for there, which is that if you pack it up into what would this amount as a sum of money, you get to see how much the license is actually worth, which gives you some information. And one of the points we're coming on to is related to what the judge said about economic theory, is that what really matters when you're talking about these patent licenses is not a rate, expressed as a percentage. That commercial people are concerned with the bottom line. And that was a relevant purpose to see how much these Optis.
But a lump sum is utterly meaningless without reference to some metrics. Take the most simple. How long is the license going to last?
No, no, my lord, you're absolutely right. My point is a slightly different one, which is that if you have a license with a minnow, and it's whatever it is, the ad valorem rate, if it turns out that, taking into account the minnow's expected sales and so forth, you're talking about a relatively small sum of money, particularly one that may not be significant when compared against the costs of litigation and so forth. That's useful information for the FRAN determination in deciding the worth that you accord to that comparable. Now, I must say that here, in saying this, that's not specific reasoning of the judge. I'm assembling different points from the judgment because he does make those points separately. But I take my Lord Justice Newey's point about the use of that phrase.
Can we suppose something different for a moment? Suppose this is all about DPU rates or ad valorem rates.
Yes.
Now, on that basis, we would be reading the judge as saying that the experts didn't try converting one to the other, and they didn't attempt to justify their approaches as between ad valorem and DPU. Now, is that a fair criticism?
What is a fair criticism is that he expected them to say, and particularly in the case of Mr. Bazant with ad valorem, given the nature of Apple, he expected some explanation, as he says, indeed, at the end of 314 Roman 1 in that last paragraph. He wants to understand, well, why are you approaching this on an ad valorem basis in this case?
And can I just pursue that a moment? I mean, even if the experts never dealt with this subject in their reports, which I assume they would have been expected to, surely in cross-examination you would have said to Mr. Bazant, well, why do you favour ad valorem rather than DPU or whatever? Did the experts not comment on those matters?
I will have to be honest, I'll go back to the record to see the extent to which that was explored on both sides in cross-examination.
In Little Roman 1, the judge doesn't say, in Little Roman 1, the judge does not say that there was any cross-examination on this point. By contrast, he says Ms. Guttridge was cross-examined on her approach to lump sums.
Yes.
In Little Roman 2.
My Lord, thank you. We'll go back and I'll absolutely check what the nature of the cross-examination was in relation to those matters. What I can say is that, at least in terms of their reports, and that's what the judge is commenting on here, he sees that the experts are essentially acting as mechanical calculators, and they're churning the figures, turning the handle in accordance with how their clients want the figures to be presented. And on this first and quite big point, he says, I would have expected to receive some assistance on that point.
Yeah, and the accusation is that firstly, the experts are straying beyond their expertise, and secondly, they're not independent because they're simply mouthpieces for their clients. Now,
Yes.
were either of those accusations put to either expert in cross-examination?
Again, I'm not going to misspeak because it's a fair question, my lord, but I would need to check. If you'll permit me, I think we'll approach it in that way.
As Mr. Speck said, those points were not put in cross-examination.
Yes.
On either side.
Well, my lord, yes, and we will check and see what the record discloses.
Can I have one follow-up before you resume? So, as my lord says, in 3112, the judge says the experts went far outside the zone of their proper expertise. Well, where? I mean, even on the fundamental, the insurmountable difficulties, I don't know how far they commented on them, but those were well within their expertise, surely. But where did they go outside their expertise?
Now, that's not clear either. He did make a comment, the judge, at one point that I think we're at the close of the trial, because I remember this part on the transcript as well as orally, that the experts, the experts were going into, I think, matters of industry expertise or licensing expertise, which wasn't their natural home. And again, I'll be corrected if I'm misspeaking on this. But it does relate to this point that you've got forensic accountants as the experts, and they're being asked to comment on something which may not be their natural home, which is in this sort of area, this quite technical area. What's the right rate? What's the right approach that should be taken?
It is just briefly following up and unfairly. take one of his three subjectivities: future royalties and past releases.
Yes.
Where he's possibly saying, well, that's outside the expertise. So he does it himself, and he's not an expert. And even if he were an expert, he wouldn't be entitled to treat himself as one.
My lord, that is quite correct. In relation to past sales, which we're coming on to, you've heard something about this already. There were essentially two different approaches that were adopted. One of those was misrepresented, so I will mention it now. The first was that Optis's expert, at least in a number of cases, said, well, I have some factual evidence here which gives me a steer as to how much of the royalty here I should attribute to the past. The other expert, Miss Gutteridge, says, as Mr. Speck explained, I'm going to approach this on the basis that I see, in the Apple licenses in particular, a lump sum, but I don't feel sufficiently reliably informed to give a professional opinion about this matter. That's her general approach. What she does not say, because Mr. Speck took this point a few times, is that there was no recognition, and there was no implicit recognition, that this is because past sales are heavily discounted or so forth. She's very clear, and I'll show you in due course that bit of her report. I think that's paragraph 651 of the first report. Yes. Do you have paragraph 651? I'm afraid I'll hand this up. Sorry. Could I have a copy as well, please? A copy for mine.
Yeah.
Okay. Sorry.
We got another bit of her report where we could stuff this in together with it.
Yes, I apologise. I think that this must be added to the back of SUP 5 as a new tab. Now, I'm sure I remember this correctly. If you go to 6.51, it's for reasons that are not my own. This is all in blue again. But if you read the introduction to 6.51, this is the Apple expert saying how she's approached it. And she refers, you will see there are some footnotes there. Take footnote 275 and footnote 277. To be quite accurate, that's how she put the case. And you should see what she says in Roman 1 as well, 6.51, 1 of course, which is what the footnote relates to.
So just make sure I've understood the point you're making. I think I can make it. Well, I may be saying things which are in blue, but I don't see how I can ask the question without doing that. So
No.
I'm going to do it. The point you're making is that she's not saying in her professional opinion whether to do X or Y was the right thing to do. She's stating as a simple statement of what she's done, that she hasn't attributed value to the releases.
That's right. And also the reason she gives for that, which is in the footnote, particularly 277, it's not because there's some form of implicit recognition. She is saying, in her professional opinion, she can't do it on the information that she's got.
Really?
That's how she approaches it.
She says she assumes a royalty-free license for any release period.
Yes.
and then simply says, in the absence of further information, I don't attribute value. She's just saying what she's doing.
Yes.
Where does she express any opinion as to the propriety or otherwise of doing that?
She doesn't talk about the propriety. What she does do is say that there's uncertainty which she can't
And
address.
to be clear, I'm not suggesting there's anything wrong with what she's
No.
doing.
No, quite.
No, absolutely.
And I take it you're not either.
That's the last thing I would do. On the contrary, the reality here is that this was a highly professional forensic accountant who was asked to look at the problem with the Apple licenses that were expressed as lump sums and to derive dollar per unit values from them. She encounters a number of difficulties. I'm not sure if the other one is mentioned on this sheet, we'll come back to it. But one of them is that she says, some of this value is for the past. She says, I cannot determine how much this was attributed for the past on the information that
That's where I'm jibbing.
Yes.
Because certainly in what you've shown us, she doesn't say that. She doesn't say it would not be possible. She simply says, I don't do it.
She says, at 6.51, if you'll forgive me for reading the blue, the last sentence, however, given the associated uncertainty, I am unable to adjust, but I rather observe their directional impact. I hope that hasn't breached anybody's fundamental confidentiality. It's regrettable one needs to speak in code, but there we are. That's the extent of the point there. The other aspect of what she did, which is a point that Apple has made in case you haven't picked it up, was there are these considerations given as a lump sum in return for the patent license. What she does say, and it may not be on this page, but I'll find it, is that in many of these licenses, she sees that the portfolio which is licensed includes what are called non-essential patents, NEPs, and not just the SEPs. And she says, I cannot distinguish how much value is attributable to those. I'm going to make the simplifying assumption, which is an assumption against Apple, that all of the lump sum consideration in every license is exclusively for the SEP portfolio.
Yeah, but I mean, just to pursue the point I was asking you about before, and maybe I'm misunderstanding something, but would you dispute that she could have made assumptions? So she unpacks on a free release basis, and she's entirely transparent that that's what she's doing. No criticism there.
No.
But she could have done it on a simple basis. She could have made some other assumption and unpacked on that basis. So it could have been done, couldn't it?
My lord, yes. It could have been done. You're absolutely right. She felt that to do it in any particular way would have been, and now I'm inferring, arbitrary or misleading.
Maybe she felt that would have been straying outside her expertise. Maybe not, but it could have been done.
Yes, and in response to my Lord Justice Newey's point on this, the judicial function does include assessing all of the facts and then taking a view. Absolutely it does, and certainly on this matter one would expect that's what judges do, assess the evidence, and you do try to have a view.
But the end result is the expert, the judge criticises the expert for proceeding this way, and then as if he was accepted, he goes straight on and does it himself.
My lord, that is broadly right. He does do that, but what he is complaining about is that he gets no added value from the experts on that exercise, and his position, which this court will have to determine, is that the way that he has gone about it is sufficiently robust. Because you're absolutely right, the court goes ahead and does this, and we'll be looking at the assumptions that he makes on these various things. you'll see that he does, for example, consider the ad valorem versus, and I'm going to put them together, lump sum or dollar per unit approaches. And there's a part of his judgment where he comes down in favour of the one rather than the other. So far as past release is concerned, that is one of the grounds of appeal, ground 9, and we'll be coming on to it directly, as to whether the judge did that sufficiently well or not, or whether it's appealable. And equally, cross-licensing is part of my friend's ground 8, and what he did there. And I'll come in due course to what our response is on that. Essentially, he adopts a simplification, assuming that the counterparty has got the same sales volumes as Apple, which is common ground, and which ends up being generous to Optis. But just to finish the point on this, and here I'm seeking essentially to introduce a degree of clarity as to what the judge did or did not do. If you go to paragraph 315 on page 396, foot, that's where the judge then pursues the point and wraps it up. He says, the fact is both experts were tasked to articulate the ramifications of the cases their respective clients were contending for. They provided no independent judgment, or at least insufficient independent judgment, for me to be able to rely on it as to the merits or demerits of those cases. So pausing there, one approach is, I've got no added value from them. It is something I'm competent to do and will do myself. Neither expert approached the problem from a stance they'd independently evolved. The direction of travel set down by the parties who instructed them, all they did was conscientiously and carefully follow the direction of travel and unpack in accordance with the principal's respective stances. So I come back because this is an important point in the case. It was one of the first that arose to the issue of the insurmountable difficulties. And what I do say is that to the extent it's a link in the chain in my friend's case, to say that the judge perceived something here that's essentially either impossible or impermissible through unpacking, that is not what he was talking about. We have to be very clear that what he is concerned about, rightly or wrongly, is that he wanted help from the experts in exercising judgment on these matters. He didn't feel that he got it. The meaning is tolerably clear from the context. Now, a related point falls to be made in relation to something else that was raised on day one. It's the judge's later reference to economic theory, suggesting that it's better to price the stack, the access to the standard, in monetary terms, not ad valorem terms. And this was also the subject of a question and comment. It's on page 477 of the judgment. Paragraph 472. It's under the heading of preference for lump sum rates. The judge says my provisional view was it was better to price the stack in monetary rather than ad valorem terms. Nevertheless, because this was a conclusion driven by economic theory, it was clearly appropriate.
Can I ask an obvious question? Because there's so much paper in this case, I may have missed something. Am I right in thinking that there was no expert evidence from economists in this case?
There was expert evidence from economists.
Okay, right, fine.
In this case, yes.
All right, where is that discussed?
There are short parts of the judgment where he discusses the expert evidence, but it doesn't. If this is where you're
referred to in this bit.
No, it's not. He refers back in this bit to another section. There are several sections D in this judgment, which is a problem. But he's referring back to the last section D. And the last section D, I think, the relevant bit is on page 466. We go back there. You have an articulation of an approach. Yes. John, hold on. Just before we talk to oh yes, no, thank you very much. So, now Mr. Speck points out quite right. If you go back, if you start at 460, page 460, right at the bottom, lessons and analysis, there's then a section where the judge is discussing FRAND as he sees it from an economic or competition lawyer's viewpoint. And you'll see from the top of page 462, he goes into the question of the nature of excessive prices and discusses that. And over the page 464, there's an exchange set out between him and Optis' expert, Dr. Gunnar Niels from the consulting firm Oxera. So far as the point that we're concerned with goes, that's really dealt with at the top of page 466, Roman 7 and Roman 8, which is essentially how the judge seems to be referring to this in the bit that my Lord Justice Arnold referred to on, I think it was Tuesday. The FRAND question concerns value to the implementer and not value to the consumer. Value to the implementer turns on a hard-nosed assessment of the sale of handsets at a particular price and so forth. He says it's better assessed in absolute monetary terms. And then he explains in the next paragraph essentially why, and says at the end of the day, a monetary price is what the market will generally produce. And he says his idea is that when you are approaching the question of what is FRAND, you should be thinking in terms of what it amounts to.
Let me ask you this question. Did any of these eminent economic experts say that all that matters is the lump sum, regardless of what price you sell at and how many?
No, absolutely not. But what I think the judge is referring to here, my lord, is not to say lump sum in the abstract, because you're absolutely right, that would be absurd. What he is saying is that ultimately what matters in the economics of a deal is how it builds up to a lump sum, given the price at which you're selling and given the number of units that you're selling.
And the period for which you're selling.
Yes, and the period for which you're selling, yes. So I don't think the judge was making a completely naive point here that lump sum is some platonic abstract concept of anything or anything of that kind. All he's saying is that when you're in business and you're thinking about how this all pans out, ultimately the business people will have in mind what does this translate to in terms of money, and they won't simply be thinking about rates. Yes, exactly. Well, if I may, at one point here, and forgive me if this is too cheeky, and it may well be wrong. In the Unwired Planet, High Court judgment, the learned judge, I think at around paragraph 468, but we should get it out, please.
Very much better than I do, Mr.
If someone can give me the reference to that. Authorities for. Thank you. Authorities for tab 1, and now I'm going to find out I've misremembered this completely. And that is the yes. So two things. If you turn to pages 112 and 113 of the judgment, my Lord Justice Birss there, two relevant points. On page 112, the judge was considering the Ericsson Apple 2008 license. You see at the top of that page, 456 and 457. And just the way that the judge approaches that, a point on this license is that Apple's selling prices per unit are very high, and so a low rate expressed as a percentage of selling price may not readily equate to a percentage of another company's selling price. Mr. Bazant, who was the expert there too, aimed to take this into account when deriving a benchmark rate by using an industrial average selling price, but I wasn't convinced the process produced results on which any weight could be placed. It adds a further level of significant uncertainty onto an already uncertain exercise. Apple's interest, and this I suppose is the point, was to negotiate how much they had to pay not to negotiate what the benchmark rate would be. And the simple point here is that in these cases, and it relates to a point that Mr. Speck referred to over the last couple of days, the parties might include terms in these agreements saying there's an option to have an ad valorem rate at a certain point in certain circumstances. But ultimately what matters is that they work out the economics of the deal, taking into account the factors that my Lord Justice Arnold rightly talks about.
And they may prefer to express it at the end of the day in a lump sum, but that's just a payment mechanism, isn't it?
It is a payment mechanism which, and I do need to come on to this too, with one important qualification, because my submission is going to be that contrary to the case of the appellant, which said that the judge's treatment of lump sums was something strictly distinct, we are not saying on the other side that the judge ought to have found that a lump sum in a license is a mathematical computation of period, the rate, the units. What the judge does do, and I will take you to the relevant parts, is he says, I accept that a lump sum bears a relationship to these matters. In fact, he says they are key to building up the number, but they're not the only show in town, because what he also saw as going into these licenses, and it comes back to a point I was making a moment ago about Miss Guttridge, is that there can be wider factors of various kinds, like the non-essential patents which build it up. And that what you end up with as the end product of the deal may not therefore be a simple mathematical calculation, regardless of how retrospectively, in the Fran determination by a court, one needs to approach these matters.
What it's worth, Mr. Turner, I have to say, reading whatever learned judge it was said at paragraph 457 of Unwide Planet, the learned judge there seems to have been talking about dollar per unit rates, not lump sums.
Well, you see in the second line, a low rate expressed as a percentage of selling price.
Exactly. And what Apple's interest was to negotiate how much they had to pay per phone, rather than what the negotiated bench rate was.
Yes, yes. My Lord, absolutely. That is the point I'm seeking to make, which is that ultimately these factors come into the deal that Apple strikes, but what they're interested in, as we've seen from something that Mr. Speck took you to, was ultimately what the whole deal is for what they're expecting to sell, and so forth, and including these other factors.
Yeah.
While you're on that page, so I don't have to come back to it, or rather the next page, if you look at what the learned judge said in relation to Qualcomm at paragraph 468 at the bottom, the only other licenses worth mentioning at all are by Qualcomm. The rates are much higher, ... I will not place weight on the absolute levels of Qualcomm's rates by assessing the level of a benchmark rate. To complete the discussion we were having before the short adjournment. And then to complete this point, and then I will move on, because to see that this is what the judge had in mind and how he was approaching his view of how to do Frand in this case and why he was thinking in these terms at all. If you go forward to the next page, yes, I think it is 478. Yes, page 478.
Sorry, just before you do, you took us back, you had been on 472, so just to orientate myself.
I'm sorry, yes, on 472.
So he's considering the merits of an ad valorem rate. As compared with a lump sum or DPU? No, he's comparing as ad valorem terms as compared with lump sum.
Oh, yes. Yes, at 472, he is there talking about ad valorem as opposed to what he goes on to do, which is lump sum. Yes, absolutely. And then he refers to that, and that was the starting point for the discussion as a conclusion driven by economic theory. And the purpose of the debate over the last few minutes is really to try to understand what he's getting at. And to complete the point, at 477, he makes it clearer in different terms. He says, at the end of the day, on page 478, whatever pricing methods adopted as between SEP owner and implementer, both will be looking at the underlined bottom line in determining what terms are or not acceptable. The bottom line is a monetary bottom line, what's going to be received in money or money's worth. And then over the page 479, you see, I mean, he stays with this point because he regards this as very important. At paragraph 478, the point's trite but very important one. The price is the monetary amount, and it's that which needs to be frowned. Not, as one might say, not an AV ad valorem rate in the abstract for every implementer, for example. How that's calculated depends on all the circumstances, whether it should be ad valorem per unit or lump sum. The same components, importance of the product, volume sold, price, inform what it is fair to pay. So he sees that these different factors coalesce and that they all play a part in deciding what matters. But he says at the end of the day, these all come into an economic question which is best answered by thinking in terms of how much money this is, given all these circumstances. Now, if we come back to the first point about the failure of the experts to exercise independent judgment, this prompts one further observation about what my learned friend Mr. Speck said caused the judge to reject the expert work, as he did. Now, Mr. Speck spent a good deal of time examining in detail the judge's reasons for saying that work product hadn't been provided to him by the experts at his request, and that Optis was to blame. The point, though, is that the judge's concerns about the expert work were not centred on a complaint about Optis objecting to Miss Guttridge's team producing simple ad valorem unpackings, which the judge wanted so he could compare them against those which had been produced by Mr. Besant. The gist of his concern, which we've now been exploring, is perhaps best crystallised on page 389 in paragraphs 298 to 299. Two short paragraphs which you can read for yourselves, but essentially the main thrust is the concern that they unpack in accordance with their respective clients' instructions. He goes on to say that they failed to produce agreed common workings of their unpacking. So he thinks even without him having essentially asked for it, if one is presenting figures on an ad valorem basis, the other on a different basis, he wanted them at least to put their figures together so that he could see what they were, what the differences were, and perhaps ask about them and explore matters that way. His concern is essentially that the exercise runs into the sand because he isn't given that help. But he makes clear in the last sentence of 299 that that isn't the nub of his complaint. He says the absence of commonly worked or agreed calculations, while it wouldn't have solved the problem of party-directed approach, certainly made it worse. So you can see what he regards as the priority or as the central point there. And it comes back to the point of the party-directed approach that we have now explored.
So Tony, I'm really sorry.
No.
Are the specifics of what the judge identifies as a party-directed approach the matters listed in 314?
Is that the subjectivities?
No, I'm looking at paragraph 314, which is the para 1 is sub 1 is Mr. Bizant was instructed, and para 2 is Miss Guttridge was similarly instructed. As I understand it, it's there that we find what the judge has identified as the specific things which he regarded as the way in which the experts had unpacked in accordance with their client's instructions. If I've misunderstood that, please tell me.
No, my lord, I think that's absolutely right. Where I would hesitate is whether that's the sum total of it, because he does talk above in that phrase that we started with, the insurmountable difficulty, was the need to grapple with these three subjectivities. That goes back to the three things at paragraph 301 at the top of page 390. One of those is the different rates that you use to unpack. Then there's the past future question, and then there's cross licenses. And what is not absolutely clear is the extent to which he is saying that he would have expected the experts also to exercise judgment on those issues. They did in different degrees. And
I didn't think that they didn't. If you see what I mean, I didn't think that the position was that Miss Guttridge, for example, was simply accounting for cross licenses, future royalties, and past releases, and whatever. I've forgotten now what number 1 means. I don't understand it as I read it here.
I think it's whether it's ad valorem or.
Oh, I see the difference between ad valorem and DPU.
Yes. Okay.
Well, that's just a pretty binary point. But take cross licenses. I mean, I may be mistaken, and please tell me if I'm mistaken. But I don't think the cross license approach of either expert was something which was. They were just parroting what their instructions were.
No, and I don't believe that was the case either. I mean, when you come to those issues, I think the frustration of the judge comes more to the point that he mentions about the lack of agreed common workings to enable him to put them together and see.
But that's why I'm just trying to understand what, in my mind, in order to evaluate on appeal whether the judge was entitled or right to reject the expert evidence or the basis that they were parroting their instructions, I need to understand what the aspects of what they did were examples of them parroting their instructions. At the moment, the sort of desert island of solid ground I've got is paragraph 314.
Yes.
But if there's another place that I should be going, please tell me.
Well,
tell me now, but I mean.
No, well, I would say that the other desert island is going to be 298 and 299, which I took you to earlier. If I may draw the strands together on what your lordship rightly says.
But it's just, I mean, sorry, 298 and 299 don't identify any points, and they assert the conclusion, but they don't.
No, but you have to read it together with it. I'm sorry, but what you do get from those paragraphs is this. To sum up, where I believe we have reached is that in relation to the choice of the rate structure to adopt, he expresses frustration that he hasn't got help on that from the experts. We've discussed the extent to which that's a criticism that is a fair one or not. When it comes to the other things that he mentions here, there the main concern appears to be, and this does now relate to the point that Mr. Speck picked up, an aspect of the lack of agreed common workings. This is a point that he repeats, is because what he wants to do, and he does, regardless of fault, and I'm not going to go into the detail of what happened on any particular days, but regardless of fault, what he wanted was to have figures, he said right at the start before the trial began, so that he could just have each expert's workings on the same basis, side by side.
He seemed to think that you would go on to one page. I mean, that was just completely unrealistic, wasn't it?
Yes. Your lordship presumably has a reference in mind, and I'm not disputing it.
It's in his letter. He asked for it on one page.
Yes, well, let me just say that was at least before the trial had started, and possibly when he was still reading it. It was a more extensive exercise. But to conclude on this, in order to understand what the judge did, that appears to be the basis of how he proceeded. And
sorry, go on.
And where we come to is that in relation to what he then goes on to do, which this court rightly observes, obviously it's not insurmountable, he goes on to do it. His real complaint is that he feels that there aren't the agreed common workings, at least on those points. He hasn't got help on the initial question of the rate structure. What is unclear, and I would not hazard a guess one way or the other, is the extent to which the concern about the party-directed approach infects those secondary matters too. In other words, to answer the court's question, the extent to which he was concerned that what they were doing there too was essentially not sufficiently independent. Because it is a tenable view that if he feels that the experts are essentially just parroting the client's instructions, then in the work that they do generally, he's not getting the help that he needs for him to be able to progress it himself.
And just so I'm clear about the basic facts, going back to DPU ad valorem, Ms. Guttridge only provided DPU, not ad valorem?
Yes. Well, so there's cries of outrage on the other side of the court. Now, so again, I'll be corrected if I'm wrong. My recollection was that she proceeded to present her information in her reports on a dollar per unit basis in her reports. The judge said, I would like some help on this because I don't see that she has done the work on the ad valorem simple release basis that the counterpart expert has, Mr. Bezant. Mr. Speck took you to the part of the judgment, where the judge refers to this, and Mr. Speck says, yes, that is the problem, because she hadn't done simple ad valorem unpacking. He says he wants it. That was, I think, on day one of the trial. It would make sense, 13th of June. Her team do go off and do that. That's the information that comes in
during the cross-examination of Mr. Bezant.
Yes, that comes in on that's what comes in on the 28th. Then, and one can argue about the rights or wrongs of it, there's at that point an objection taken by Optis. You shouldn't look at this. The objection is repeated after the trial, as Mr. Speck showed you, in October that year, where they say we weren't able to cross-examine on this, is unfair for you to take it into account. And the judge expresses his frustration at the point in his judgment where he says, I'm not going to rely on the expert evidence in these circumstances.
And so that's Ms. Guttridge. In terms of Mr. Bezant, he provides ad valorem calculations and never provides DPU calculations.
I believe I think he does after the reports, as Mr. Speck, I think, took you to, provide dollar per unit analogues in answer to the question 2 of the judge. There's then a question about whether he's provided what was this difficult concept. But I hope I'm
sorry, that's wrong.
What
he
is
provided some DPUs in, I think it's his 5th report, so that they could be compared with Ms. Guttridge's free release.
Right. Okay. Well, I'm not sure of the precise sequence when that report came through, but regardless, he did provide that work. The concern here by the judge relates more, as you will have seen from the parts of the judgment that Mr. Speck took you to the objection, the blocking of the admission of the new material on Apple's side, which were the ad valorem rates on the simple release basis from Apple's expert team.
Yes,
and that is the story. And I'm going to.
One more question from me. Sorry, Mr. Turner. Is it? I think on this appeal, you're not saying that the judge was not entitled to. It wasn't open to him to reject your expert's evidence on this basis. You're not saying.
No, we're not.
We're saying it was open to him to reject completely your expert's evidence on this basis.
We are saying it was open to him to reject the expert evidence of Miss Guttridge as he did and to adopt the approach which he chose in simple terms, because as I hope to show you, it is something that had a solid basis in the evidence and argument that he was receiving, essentially based on the Apple.
Just forgive me for splitting it up. It doesn't matter what he did subsequently. Your position is, as I understand it, that he was entitled to completely reject Ms. Guttridge's evidence. What he does subsequently can't have anything to do with that. They can't justify something or not.
No, absolutely. He was entitled to do that.
Right.
Yes.
Thank you.
But what
No, I
goes
understand.
with it?
You go on and say, I understand.
Well. Yes. It's just that it sounds, when you put it just as that proposition, that there's the other side of the story that goes with it. He's allowed to reject it in favour of what he does go on to do. So I think one has to complete the sentence and read them together.
Thank you.
Now I'm going to endeavour to complete my first headline point. The other one that I flagged is the theme in my friend's submissions that the judge repeatedly defied points that were common ground. So that was also, I haven't counted the number of times that was said, but it was said to have happened on many, many occasions. My opening submission on that is that submission too is overheated and it was materially wrong insofar as it is relevant to the issues in the appeal. And let me take one of the issues in the appeal. Take the claim that was made that it was common ground that 3 of the Apple licenses were useless as comparables. And the judge nonetheless defied this. The 3 licenses were a license from KPN, from Orange, and from Etri. It's a research institute in 2017. Said to be common ground. In fact,
are you telling us that that's wrong?
Yes.
Or because Mr. Speck showed us documents from your side that expressly said you weren't relying on them?
He did not show you the documents from his side which said that he was relying on them.
I see.
Apple didn't rely on them, my lord, that's true. Optis's case for the trial was that it would address the totality of the licenses considered by the experts, which went wider than those that were positively relied on. And Optis's own expert did cover them in his report, even though he himself positively relied on 2 out of the 3. So if I may show you that in supplemental volume 5, and I hope I've got all of the correct extract, supplemental volume 5 at tab 5. So this is Optis's case for the trial. This is their opening skeleton. If you go in it to page 22, 3 pages in, the way it was put, if you look at the bottom of that page 22 at paragraph 193, here up at 192, both Besant and Guttridge agree the better approach to look at the broader set of potentially useful comparables, leaving aside the parties' positive cases. Below, they say at 193, we address the totality of the licenses considered by the experts. We do so by reference to the licenses that the parties rely on in their positive cases, and also by reference to the other licenses throughout, as this accords with the approach taken by the experts. So,
The fact that they address the licence, you say, is the same as positively relying on.
well, in their skeleton here, Optis was saying we will essentially rely on the cases, on the licenses that were considered by the experts throughout, the totality of them. And what they then sought to do was to do that. It was the judge who said, I'm going to restrict you in your positive case to those that you are positively relying on.
If you look at the very next paragraph, 195, the
195.
experts are in agreement that 5 of Optis's licence and a blued out number of Apple licences are of no utility at all for a variety of reasons. And then there's Are you referring to the last sentence? Further, the Apple license, Mr. Guthridge does not consider use of Mr. Besson.
Yes, and if you look at
what you're referring to?
Yes, and if you look at the footnote, you'll see the first of those, which is blued out, so I won't mention the colour that is referred to in blue. And the second, you'll see an acronym, which is one of them. Now, the odd one there, I confess, is that is two of them, and so I'm just drawing to the court's attention for common ground. You see the way that this was presented to the court. The one that is more difficult is the ETRI 2017 licence, that one, because in that case, as my Lord Justice Arnold has picked up, their expert said he wasn't going to positively rely on that. My point is, and we can, I'm not sure, have we got table 3.2? So I'll show you an extract from his report. Nonetheless, he covers all these licenses in his report. He's got the data from Apple. He produces his tables of analysis covering these licenses, and that includes that one as well. But in relation, at least to the orange and the KPN one, you see, my lord, what the situation is. So let me just pass. Sorry about that. Sorry, I must apologise for this piecemeal approach. So this is a table from Mr. Bizant's report, and if you just run your eye down, you see yes, you see it's a 1, 2, 3, 4, 5, 6, 7, 8th row down. That particular license also as part of the analysis. So the point is that the way that the case is presented, this is not common ground, and my Lord Justice Arnold was right to pick up on that footnote, which explains the matter.
So presumably from this table, Ms. Guthridge must have analysed those as well, since this is a responsive table to something about Ms. Guthridge's rates.
Yes, I believe so. Yes.
All the same licenses, orange and ETRI and whatnot.
Yes, yes. So again, when you're considering this ground of appeal, which is ground 5, the point is, A, it's not common ground. I hope I've just explained the situation in advance, and you see the way that this information is used, at least by Optis, and the way that the experts deal with it in their accountancy reports. And my last point within the first observation is that Mr. Speck spent a fair amount of time too on Tuesday and yesterday comparing the reasoning in the draft judgment to the final judgment. And I will come to that, of course, in the context of what is ground 25, the anchoring or apparent bias allegation. But an immediate point which falls to be made is that a comparison between a draft judgment and a final judgment in these courts, with a view to attacking the cogency of the judge's substantive reasoning in the final judgment, is neither here nor there. You ask yourself, is the final judgment on its own terms wrong or right? There can be circumstances in which it may be helpful also to look at an embargo draft judgment, and we agree with the observation that my Lord Justice Arnold made in that regard. But the essential question remains, final judgment, is this right or is this wrong? Now, one example was that on Tuesday, Mr. Speck pointed out that in the draft judgment, the judge missed, when he produced that document, an element of the consideration which was paid by Apple to Qualcomm, a big element of the consideration. And when this was pointed out to the judge in corrections, Mr. Speck points out that Qualcomm's position in a table of comparables in the final judgment now moves, it changes, it goes up. And he said, and I'm quoting the transcript, the judge now says that there's a compelling case for exclusion of Qualcomm, but he's decided to make an adjustment rather than exclude it entirely. What is happening here, as in many of the cases that were referred to, is that the judge has produced a draft judgment in which is, on any view, an extremely complicated and difficult case, not with inordinate delay in producing it, and he is taking on board, because he plays it back to the parties, lawyers and their experts, he takes on board an error that he has made, having asked explicitly for help from the parties and their accountants with what was a difficult judgment, to help him fix it. This is what you see repeatedly. There was no seismic shift in position either in the final judgment, which was often the submission that was made. If you pick up Core 2, which has got the draft judgment, and just look at this single example, Core 2, page 328, you see paragraph E at the top, where the judge states the problem that he perceives at that point with the Qualcomm license. Then if you go over the page to page 329, you see at that point where the judge has got wrong the amount of money that's being paid to Qualcomm. His reasoning is at Roman 4 at the foot of the page. I've thought long about excluding Qualcomm from the average. And then you get a sentence in blue that I can't read out. And what he says, you'll see his reasoning, final sentence, I can see considerable justification in excluding Qualcomm, but on balance, I consider that inclusion is the better course. That was the draft. And then when the figure is corrected and it's shown that the amount of money is much bigger, the impact is much greater, what happens is that in view of the implied stack price soaring for this Qualcomm comparable, the judge adopts a different approach. The balance changes. And we've talked before lunch about the way that he approaches it. But if I may say so, this is not an attack on the cogency of the main judgment to pick this out and then make that form of comparison. And I would caution this court about adopting that approach. Finally then on this, stepping back, I am not going to spend any more amount of time going through points of complaints or obscurities in this judgment on the judge's phraseology. I will say that the relevant question for this court is whether the errors alleged in the ground of appeal are borne out or not, and that is the only thing that I shall concentrate on. Now my second headline observation, and this will pick up, but if I may, I do think that these are important points to ventilate at the start of the case, is an issue of materiality. I would like first to give some context to the Fran decision that the judge did come to. You heard Mr. Speck's argument about that and the complaint that on any view, and he pointed to different metrics, this is far too low. This is much, much too low. And second, I'd like to pick up on the point that was raised yesterday about how the Google license sits in comparison with other information in the case, and what that shows this court on a very important question for the appeal, which is the issue of its reliability as a comparable. So if I may, I'll start with the first point to give context to the judge's valuation of the Optis portfolio. And my friend suggested on numerous occasions on Tuesday that the judge had reached an outcome which is irreconcilable with Apple license comparable data that he had before him, and he awarded Optis a royalty that was manifestly too low. And he said on the transcript this equated to about 2 cents on a dollar per unit basis, 2 cents. And you'll recall he particularly emphasised as a comparator, to give you a sense of why this is too low, at least on Tuesday, the rate paid to one of the counterparties, which was Ericsson. So my submission is that that suggestion, that is an approach from which you can derive, you can infer that this is manifestly wrong of the judge, was misplaced. If I may, I'll go to a document that Mr. Speck spent time on yesterday, and we heard a bit about today as well. It was the document at SUP 4, tab 26, which is that coloured table of workings with the figures. Please forgive me for raising this late in the afternoon. Page 223. So here you have the recent multicoloured tables produced by Optis. There's been an issue about the rounding questions. That needn't detain us now. Please go in this to the second box, which is Mr. Bizant's free release calculations. That's the second table along. And you'll see in the columns large number of figures corresponding to the counterparties on the left-hand side in the different rows numbered 1 to 19. And for each, conveniently, you see the stack share of each of those stated. Now please look at the second column in that box, which is the scaling of those dollar per unit rates paid to those counterparties, as if it was Optis that you're paying with the much smaller stack share of the 0.38% that Optis solicitors refer to. And Mr. Speck draws attention to the figure for Ericsson, which you can see there in row 3. He compares it, we compared it on Tuesday, with the implied 2 cents for Optis. And he says, well, look, you can see it's wrong. My submission is that when you look at this table and look at all of those figures, Ericsson is not representative on this basis. And I ask the court to look at the rates paid to some of the other major licensors. And just to be on the safe side, please tell me if this is too obscure. You take the large one in row 11 and read across. You see 4 cents. Oh, right. Yes. If you take the one in row 16 and read across, you see a number there and compare it against the 2 cents.
John, you're allowed to say who they are.
I'd understood that it was the combination of the number and the name that was the problem. So I'm referring.
So if you're giving a number,
I'm giving you the numbers, and you can read the names.
Yeah.
Someone once said monkeys have tails, but Court of Appeal judges can draw their own conclusions. Now, the one thing we do know about the Optis portfolio, when you look at those numbers, is that the finding of fact in the case is that it was below average in terms of quality. And what you're looking at, even on that, where it's all been scaled to Optis, is a range of rates. For major licensors, where one cannot automatically draw the conclusion that their larger portfolios are below average in terms of quality. That was the specific finding in this case. And when you think about the 2 cents that the judge, as Mr. Speck says, awards in this case, this is helpful in providing that context. And I say that to complete the point that Mr. Speck was making with his single comparison with Ericsson on Tuesday.
Can I just show that I've entirely missed something? We get with each of these DPU unscaled under the Besant headings. Is this Mr. Besant providing, I mean, did he provide DPU figures for all these licenses?
I'm told yes. Am I right? Yeah, yes.
So just reversing back to where we were, he provided ad valorem rates for all the licenses. He provided DPU rates for all these licenses. So what didn't he provide?
What he did do, he, in his ad valorem approach, just to be absolutely clear, I think right from the off, adopted a slightly different way, materially different approach from the case that Optis was itself advancing at different points. So just as a preliminary, Optis was at
hardly redolent of parroting his instructions.
Well, my lord, that may depend on where the client feels the case has got to at the time when the case comes to trial. Because the point is that at the time of the pleadings being commenced, as you'll see in a few moments, Optis is asking for a pure ad valorem rate on the Apple handset units. At different points in negotiations, they say that that should be capped at selling prices, and they gave different figures, 470, am I not allowed to say? There were different caps on the selling prices applied to Apple. Mr. Besant, as your lordship picks up, he then came up with his own cap. And because it was lower than the generality of the prices at which Apple handsets go for, it essentially operated as a dollar per unit rate in relation to Apple.
So just going back a moment, the judge complains, well, he hasn't got data to compare provided by Ms. Guthridge and Mr. Besant, at least on DPU, seemingly he did have such data.
Well, my lord, on that question, I am driven to say yes, because of course it was Apple's case that the judge could decide the matter on a dollar per unit. Would decide matters on a dollar per unit basis, and that's the way it should be approached. So I come back to the observation that I was making earlier in debate with the court about what the judge must have meant here. So far as which rate structure to adopt is concerned, we know what the issue is there, and he says they just didn't help them there, they just did what they were told. When it comes to these matters, the concern appears to centre on this lack of agreed common workings, and that therefore he didn't feel that he was able to work with the data because that's what he wanted to have.
So, I mean, we haven't got all this material, but if I were to compare Ms. Guthridge's DPU rates and Mr. Besant's DPU rates, I mean, we can see the free release ones here, I think, can't we? In 2A and 3. I mean, they're not actually so terribly far apart, but they are a bit apart. Could one not, by looking at the reports, see what the differences are?
In relation to this, yes, I say that the judge could have gone down this path. What I say, however, is that the point the judge appears to have taken is that in producing these figures, he wanted there to be agreed common workings and engagement, if one takes that, and he felt that he was not getting the assistance from the experts that he required. The extent to which that was infected by a perception that a party-driven approach was behind it is something on which I'm unable to comment. But what you do see is that the party-driven approach point comes out as the thrust of his main concern. So, my lord, next, I'll stick with this same box if I may. So I've made a point developing what Mr. Speck said about this. In the same column of DPU rate scale to Optis, could you please look at what the average value is there at the bottom? Looking at the weighted average, I'm just looking at the average value there, which I'm going to take it I'm not allowed to read out. And right, I'll be. I've got a hatchet man behind me if I'm out of turn. But one asks oneself, why is that such a high number compared to the rates that you've just been looking at going down that column? The answer is this: that there is one giant warping the average because of its colossal size compared to all of the others, and that is in row 17. And you see just how much that number overshadows all of the others. Now please consider look at the column on the left, the raw dollars per unit that are just paid to each of these licensors for their portfolios for each handset sold. The first column in the second box. You see there that the Google rate is a very high number. Just read across from row 17. Can I mention that number? Yeah. I can't mention the number, but you see it corresponding for row 17. If the court's got it, you see that number?
Can I just check which box you're looking at?
Yes, I'm looking at the DPU unscaled, that's
Yes.
raw dollars per unit.
Yes, I see.
How much is paid by Google to Optis for every handset that it sells?
Yeah.
I'm looking at the Bazant free release figure on that basis, yes. And I'm not going to say the number.
Yeah.
So you see what it is, and if you look up the column, you see that that absolute number that needs to be paid is a higher dollar rate per handset than any of the big beasts in their licenses. So if you look at Ericsson, look at row 3 or row 4 or row 11.
But row 2 is bigger still.
Yes, yes, absolutely. This is on an absolute basis in relation to some very big players, is my point. And now I ask, what happens if we stress test this Google number along similar lines to those that were urged by Mr. Speck yesterday? So take the absolute dollar per handset rate, which is paid by Google, in the first column in box 2. So you see that's the big number corresponding to row 17 that I'm not allowed to read out. It's a 3-digit number with a decimal point.
Yes.
Yes. So now let us suppose that that isn't 0.61%. You see, read across, that's the stack share. Suppose it isn't, and adopt Mr. Speck's thought experiment and say, well, okay, imagine it's 1%. So imagine they've got a 1% share, and that's the dollar per handset that's payable. And then multiply that by 100, and you will get an amount in dollars to be paid by whoever the handset seller is for the stack, which is a 3-digit number with the decimal point right at the end. And to see what that means, that number, in the context, the real world of the handset industry, and I know that the court will, to a large extent, be taking judicial notice of this, can I show you what Mr. Bazant puts forward? He was the expert in a different case, the interdigital case, and he puts forward this is the industry average selling price for handsets at around the same time. So if you pick up Authorities Bundle 2, go in it to, this is Mr. Justice Mellor's judgment at tab 2, and go to page 256. and you look at, I think it's paragraph 847, Roman 2, at the top of that page. So this is, it's different judgment, but you see there that the same expert is saying around the same time, that's what we look at for the industry average selling price for a handset.
Well,
I'm sure I must be able to read that.
yeah, I'm sure you can read it out.
So it's an industry average selling price of $220. And that's for 4G, which is the stack that we're considering. Now, if that's the average selling price for the mobile handset, you compare that against the figure for the stack that the handset owner must pay for that cost input for their business. And you can see immediately that it is baldly uneconomic. May I say, it doesn't help to halve the number and pretend that Google has a 2% share, which was the other version of the thought experiment, so that 3-digit number, drop it in half, because the resulting 3-digit payment for access to the standard is, in my submission, still, well, it's still 3 digits, it's still plainly uneconomic. Now, in answer to an observation that my Lord Justice Newey made yesterday when we were considering Google about the desirability of some cross-check if you're doing this valuation exercise, and if you're being asked to base valuation on a single license in a case, we say that you absolutely do need something of that nature to give you a cross-check, a sense of context in this particular case. In the Lenovo and InterDigital case, Mr. Justice Mellor, it's true, did pick a favourable comparable. It was a favourite out of 7 that he considered informative, and which could be used as a sense check against the selected single comparable. But even the very basic sense checks of the Google rate that I've just taken your lordships through fail. And that's even if you exclude any consideration of the Apple licenses as part of what the judge is doing in this Fran determination. So then your lordships may ask, well, are we saying to the court that Google, a large and reputable company, allowed itself to be hoodwinked by Optis into a terrible non-commercial deal? And is that really plausible? And to that, we say that the Google deal may well have been the commercially correct decision in the circumstances, but what it isn't is FRAND and a reliable FRAND comparable. Because the issue confronting Google is that even though on the metrics applied by court in a case of this kind, it might not be a FRAND number, it might well represent a good commercial deal, irrespective of the size of the company, when you take into account all the circumstances, including the transaction costs of litigating to reach a much lower, and we would say, FRAND value. And this then opens a question of approach for the court about how one views comparables in these cases, which was discussed by Mr. Justice Mellor in InterDigital, and we find it recorded, my lords, in your judgment, most conveniently, so authorities 2, tab 4, page 298. So in the first part of the Court of Appeal's judgment here, there's an explanation of the chain of reasoning of the judge below, and you'll see at paragraph 68 reference to how Mr. Justice Mellor approaches matters, and he said, when the sums payable by the larger implementers, often lump sum deals, are at least a degree of magnitude higher than the cost of litigation, it seems logical to assume the unpacked rate is more likely to represent the true value of the licensed technology. By contrast, where the cost of litigation would be around or greater than the total sum payable under a license, it's far more likely the implementer has little choice but to accept what the licensor is demanding. Certainly InterDigital's licenses seem to fit this logic. Two comments. The first is I accept that the Court of Appeal does not endorse in express terms what Mr. Justice Miller said. Nonetheless, it records it in the judgment. The second is that this comment of Mr. Justice Miller about the implementer having little choice is not a point about little implementers, it's about little choice. And it's saying that where the transaction cost, the cost of litigation, are in the same ballpark as the amount of money you're talking about, that affects what you're prepared to do and whether you're prepared to go on and engage in FRAND litigation. And so far as this case is concerned, the members of this court may well be very familiar with the kind of unusual costs that this sort of litigation does entail. May I ask you to turn up in Core Bundle 3, sorry, tab 5, which is it's Apple's responsive position statement, it's called, before the trial, where a point was made about the costs of litigation, essentially picking up on the same theme. So you go in this document at tab 5 to page 127. There's a table at the top. There's a table at the top, table 1, estimated total payments under the Optis comparables versus costs of litigation. And you see a comparison of the money that had been received under the licenses, and this does actually give you a flavour of what those licenses amount to in money terms. But you'll see the actual lump sum paid and compared against the costs to Optis, various elements of this litigation, in the bottom right hand, no, where is it? Yeah. Yes, you see it in the right hand column. This is Optis only.
It's my fault, but I'm not understanding this because it says the way the table's presented, it's as if you're supposed to read across. But am I right in understanding that you don't read across?
No, you're right, Melda. I think that the division is down the middle.
Yeah.
And the estimated total payments for the Optis comparables are on one side, and then costs are on the other.
And with this particular one, we don't get either a dollar sign or a pound sign.
No, I saw
It's
that.
large, however you look at it.
No, I saw that too. So
Yes.
I'm not sure which it is.
But presumably, yeah. So we can see what these costs are. So A to D are the technical trials.
Yes.
F is Apple refusing to undertake to abide by the court determination, despite being found to have infringed valid patents. So those are what those amounts are.
Yep. And then if you look at the footnote 16,
And the point is what? Because...
So the point is that the total payments, if you look at the total payment under the Google license, bottom row, on the one side, you're comparing what are the costs of at least this FRAND litigation. I take your Lordship's point about trial F, but you're looking at the total costs there of the technical trials and trial F, and then the footnote, because this is January 2022, and the FRAND trial takes...
What's the assumption that you're asking us to make? Are you asking us to assume that it was in the contemplation of Google that they would be A, sued on all the same patents, B, in the same jurisdiction, they would also, I think you said leave aside trial F, but you must, I think, be asking us to assume that they're contemplating being sued on exactly the same patents in the same jurisdiction.
My Lord, one qualification to that, I am saying that Google will have been thinking to itself, if this goes to Fran litigation, it's going to be expensive. I'm not making specific observations about exactly how they will have calculated matters would have developed. If one takes the Fran trial itself, trial E, we're now on the appeal of that, the footnote refers to as of January 2022, which was...
But how does this work if one assumes that what they were afraid of was being sued in Germany, where allegedly proceedings are much, much cheaper?
Well, my Lord, what I'm doing is I'm referring to here what may have been the case if it was thought that infringement proceedings would be commenced, let's say, in this jurisdiction. Maybe your Lordship has a point if Germany is far, far cheaper. I would accept that. But what I am saying is that the costs of Fran litigation, at least in this jurisdiction, are not a million miles away from the license amount that Google agrees to pay the licensor in the case. It's not a more intricate point about precisely how that would have unfolded, but it is a point that when the business people are saying, well, where might this go? What would be involved? The tying up of costs and time. We come to the point that Mr. Justice Mellor made, that's recorded in the Court of Appeal's judgment, about how one treats comparables of this description. Yes, I'm reminded that Google was sued by Unwired Planet, both here and in the United States, as a factual context. Thank you.
Senator, is it fair to say that this point applies to a number of Apple comparables?
That, I think, is less certain, because the judge makes the point that in many of the cases where you had small counterparties on Apple's side, you were still talking about substantial sums of money. However, I will accept, and I will need to check it, that there will be some cases in there where the sums concerned are going to be, where the same argument may apply. I prefer to go away and check that.
Yeah, of course. Thank you.
Now, there's one final point to make, which is based on Mr. Speck's appendices, and you've probably put that away, but it's the simple point that the Google license is not for the same portfolio as the Optis portfolio in this case. There is an overlap. The Google license, and someone will tell me if I believe I've already said what the figure there is, 0.61%. We discussed it in court yesterday, so there can't be a problem. That was 0.61%.
That's why it gets scaled to 0.38% in
Yes.
the appendices.
Yes. Yeah, there's a difference. What is the difference? The Google license, the main difference, it included a group of patents, which are called in this case the X-Ericsson patents. They were licensed by Optis to Google. Those, for reasons we know about, aren't part of the Optis portfolio license here, determined by the judge, so they came out. But the Google license excluded certain patents that were formerly owned by Samsung. Point I was making a moment ago, Google was in litigation here. That's Unwired Planet with another connection to Samsung. The Google license excluded those, and they are to be included in this license. So in terms of size and composition, there is, in my submission, a material difference, and it is wrong to have been saying we are talking about the same portfolio. We're talking about two overlapping small portfolios, with those differences. The result, as my Lord Justice Arnold rightly says, is that the overall size of these two portfolios differ by the ratio of the 0.61% and the 0.38%. So that's my second point. I've taken some time. I hope that is also nonetheless helpful for the court's decision. The third point concerns the significance for the appeal of Optis's, we say, erratic and sometimes opportunistic approach in the course of the proceedings as a whole. And I include in that this court, the arguments that are taken. My friend refreshingly said yesterday, well, we'll be happy with whatever you decide, to determining the value of the portfolio and what follows from this for the approach that this court should take. I'm not going to labour the point, but I do need to say this. It is a case where the SEP owner has repeatedly reformulated its case on valuing the portfolio, and it radically changed the evidence on which it proposed to rely. A number of instances of that are recorded in the judgment, and they happened after the parties' pleadings, the position statements, were lodged. It happened both in the run-up to and during the trial. There's only one instance that I wish to draw to this court's attention, which was referred to by my friend only very briefly and in my submission inaccurately, looking at the transcript. It is on page 297 of the main judgment, which is on, yes, page 297, paragraphs 139 and 140. Now, the point that's made by the judge in those two short paragraphs is that in the course of closing submissions by counsel and unheralded by anything that had gone before, Optis shifted its case to rely on data which hadn't been part of the dispute or raised in the pleadings or in submissions. And in the last sentence of the footnote 164 on that page, the judge refers to this additional material, which wasn't foreshadowed in the pleadings, in his words being simply thrown at the court. We have pointed out in our skeleton argument, paragraph 42, that the impact of this newly argued point at that time did not lead to a coming together of the parties' positions. It involved a spiralling of the claim to around $7.4 billion for the Optis portfolio. And I say that because the changes in case, as we perceive it, do continue in this appeal. That is not simply the new argument that the court should decide that the Fran value should be derived from two comparables which are extreme outliers in Optis's favour, and which, if you take now what is, as of yesterday, the preferred lead comparable by itself, that produces a royalty for Optis. It estimates in its own skeleton, paragraph 9, as I'm told I can say, several $1 billion. It's paragraph 9 of their skeleton. You'll see the upper figure, and that comes from the Google license. So that's one point. The same type of behaviour, we say, marks, and this will be developed by my friend Mr. Mercer, Optis's attempt in this appeal retrospectively, as we see it, to bring into the forefront of the UK valuation of the global portfolio parallel American proceedings in respect of 5 patents, where they treat the jury award, which is subject to appeal, either, in substance, effectively as a flaw to the UK court's assessment, or what they say in their skeleton at paragraph 71b, as a real-world cross-check to the patent court's valuation exercise. That's 71B.
I don't remember Mr. Speck pursuing that point. I may be wrong.
Well, if it isn't pursued, we're glad. It's part of the written case. It was no part of the case at trial. And our submission is the prosaic point that particularly in a case of this kind, a valuation case where what we've heard is that small changes can lead to absolutely huge impacts on the one hand, where the outcome, the figure determined by a court in the Fran valuation, perhaps as my Lord Justice Birss now knows to his cost, then become broadcast across the universe. These determinations matter, and it's particularly important to hold a litigant to their case punctiliously and not to treat this court as a second court of first instance for Fran disputes where one party doesn't like the result, waiting in the wings for essentially the loser to present a newly repackaged case and then ask you to decide it in what is an accelerated fashion, in my friend's term, at a lick, and to use my own term, on the hoof. That's the structural point. And then from Apple's perspective, if I may say, there is a concern that it does cause injustice to the opposing party. On our side, and I ask the court to put yourselves in Apple's shoes at this point, if you now hear that this single comparable is achieving this significance, with a concern that this will lead to an outcome in which they have to pay several $1 billion to Optis for this portfolio, then one does think, well, my cross-examination would have been different, the way we focused on this would have been different, the case would have been different.
Yes, well, the point you make is well understood, but I think it does lead to this question. Suppose we come to the conclusion, and that is obviously a big if,
Yes.
but if we come to the conclusion the judge's approach, e.g. because of his use of his own methodology, was flawed,
Yeah.
Is it seriously your client's suggestion that this case should be sent back for a retrial?
My Lord, that may, if your Lordship comes to that conclusion, what I would say then is that then, depending on the circumstances, there may be a choice as to whether this court can deal with it or not. I'm not saying it's binary, in that if your Lordship decides that the judge got it wrong, it necessarily means that in every set of circumstances it must be sent back. I do not say that. The court will consider the different features for yourselves. But what I do say is that looking at it from the point of view of a litigant in these sorts of cases, if there is a choice to be made between, on the one hand, potentially what appears to the litigant as an exorbitant figure being determined on the appeal court level.
Yeah, but there's an answer to that, which is that this court doesn't award an exorbitant figure.
My Lord, I understand that point. Let me rephrase it. If, as a result of what will have been a very concentrated procedure before this court, in which this court has only really done the island hopping that Lord Justice Lewison referred to, and that's why you're being presented with all of these different pieces of information, you were then, and to take the case in point, to take this single license and use it as the basis for a determination without having heard all of the relevant argument that would need to be addressed to it if that were to be considered, if that were the case at the Fran trial, that would give rise to a legitimate sense of injustice, and it would be the wrong outcome. Were you, on the other hand, we've now looked at the range of numbers in the that spreadsheet of Mr. Speck, to approach matters in a different way and to take on board more of what the judge did, if you were not to treat that single comparable as the sole determinant of the outcome, that is why I say it may not be binary. My point is that we have been looking at a particular figure now. The sharp end of Optis's case is that this figure determines
everything. So there seems to be a submission that whether it's right to order a retrial depends upon whether the result of doing it ourselves would be to, say, increase the judge's figure by 50%, to take an arbitrary number, as opposed to 500%.
My Lord, I don't mean to make that submission. Of course, if there is a dramatic increase in value, subjectively that would give rise to a sense of disquiet. But my point is that if that arises as the result of a highly compressed process where
I'm
this
sorry,
court...
I just don't understand your position.
Yes.
I can understand perfectly a submission that says we simply can't do it, and therefore a retrial is inevitable. But you clearly don't want to give that answer. And so therefore I'm struggling to understand what the logic of your submission is.
My Lord, the logic of my submission is that if this court were not to jettison entirely the judge's approach and instead to do something which is dramatically different, the way that Mr. Speck developed his case, but to take on board all of the data. And so let me put it differently. If we go into what we call the errors of implementation, the grounds from 5 to, as it is, 9, because 10 at this level the court is accepted. If you were to say that this is a reasonable approach, and I will seek to persuade you that that is the case, even if you were to find that in the way that he carried it out, he made errors, because, let's say, he should have dealt with pass release differently or something of that kind, this court could, in those circumstances, substitute, as a matter of judgment, based on material, a different view, and we understand that, and I will be addressing it. My concern, and it's why I say it's not binary, is that this is obviously a highly compressed process where this court does not have access to the same evidence. You have been treated to extracts from cross-examination, documents. I'm in no position to pull the other side of the record and show it to this court completely, certainly not within the time frame I have. And therefore, to decide the case, we say, on that basis, which would be remarkable, would be the wrong approach. I understand your lordship's point. Am I saying this as a matter of essentially partiality? I'm seeking to do this looking at it through the lens of what is just. And my submission is that if we focus certainly on the Google license, and to answer your lordship's question bluntly, yes, if you were to take that and to make a decision on that basis, for the reason I've given, I would say you should not do that, and that should be returned for trial, if you felt that that was potentially the correct approach to have taken. And then there would be a case in which that was argued and that was treated as the correct approach. So, my Lord, I've now covered, thankfully, 3 of these headline observations. In the remaining time, I'm now going to pick up some speed. I'm going to at least finish the headline observations and then get through the case. The 4th observation involves looking at the content of Optis's pleaded case, and this is to pick up on the point I have just made and the issue of what is just and how this court should approach its determination. It is important on this appeal to consider what is pleaded and what is not. And if we could please pick up the core bundle 3 and go in it to tab 2. This is the latest document. It's called Amended Position Statement. It is effectively Optis's up-to-date pleading prior to the Frand trial. And you'll see on the front page, page 22, very helpfully, second paragraph, it is stated, this position statement sets out each proposition and or approach that Optis intends to advance at trial E, and upon which Optis will be asking the court to place reliance and or find in its favour. That's what its purpose was. It's effectively a clear pleading. And if you go in it to page 27, at the top of the page, paragraph 11, you have the three methodologies upon which Optis was relying to support its case on valuation. The first and primary method at that point was called scaling from unwired planet. And this was to treat the rates in the court-determined licence produced by Lord Justice Birss as not merely persuasive, but effectively as binding on the world, subject only to being scaled to match the portfolio of this licensor. And before I make a further point, if you could turn to page 21. What, page 21? No, hold on. I have in my, so this is my note, paragraph 24, page 31. Because I just want to return to a point that Mr. Speck made this morning in housekeeping at the beginning, in answer to a question from the court, which was whether this weighting approach for stack shares was both parties' approach. And he showed you two documents, or more than two documents, documents from both sides. My submission is that that was not quite right, because those weren't the parties' cases, those were illustrations in the parties' cases of the magnitude of the effects that were in play. But you look here and you see Optis's case, principal case stated. This is the comparables case. So we've moved on from scaling from unwired planet. And at paragraph 24, you see the steps taken for the comparables methodology explained in lucid terms at 24A to D. And if you, that's then implemented in the following pages. If you go on to page 34, look at paragraph 34 at the bottom. I'm not sure if I can read the grey.
You'd like us to.
But if you read it, you'll see there that they're contending in their pleaded case at that point for those ad valorem rates. And there's a chart above the top of the page with the different Optis comparables, which was their preferred group. And there's no weighting of stack share or anything like that. And I mean exactly the same for the Apple case, but in the interest of time, I'll give you the reference. Our position statement at core 3, tab 3, page 61. If you look at paragraphs 45 to 46, we're not approaching this on a weighting by stack share basis. And by the way, neither of the experts do in their assessment of the comparables. Now back to the unwired planet approach.
Hang on, why would you wait for stack shares? These are Optis licenses.
Well, here.
Yeah. You wouldn't. Doesn't mean anything.
Well, this is all in the same portfolio. That's no. You're
I mean, I may be wrong, Mr. Turner, but I mean.
Oh, I see. No, I've pointed out that some of them, as with Google, were for materially different portfolios.
Well, even on your own case, it's overlapping.
No, I understand that. But nonetheless, you see the way that Optis was saying it should be done, and in their approach, for my Lord Justice Birss is right, essentially. You see that for that group, that's the way they approached it. For Apple, and we can turn to it if the court desires, again, they weren't approaching it, although there was the illustration that my friend rightly drew attention to. It was not the gist of the approach. The gist of the approach was to say, here's a spread of dollars per unit, here's a range, and you're going to have to make a decision where in the range this falls based on various considerations. Now, if I may return then to the point about the Unwired Planet scaling case, the judge below records that that approach to the valuation exercise was also a central and consistent feature of Optis's negotiations with all the counterparties when agreeing the terms of the patent licenses, which Optis then comes to rely on as the chosen comparables at the trial. So if you put that away and go back to the main judgment and go in it to page 334, this is within paragraph 200, 334. If you look at Roman 2 at the top, you see considerable reliance after hand down of the judgment in Unwired Planet is on various rates tied to and seeking to leverage the judgment of a highly respected highly respected High Court judge and jurisdiction. And then there was the reference to it being the court adjudicated rate. And you see the footnote. I won't show you the document, but Optis even went so far as to duplicate the template for your judgment in their own negotiating documents. So that was the approach that was taken. In the dealings with the counterparties, Optis claims to be legally entitled to what it called the true Birss rates. And you see the position that was taken in relation to Google in particular at the foot of page 379. Paragraph 268, where there's the heading Google 2020 Optis. And you see if you read the first three sentences, the last of those has been put in blue, again, for some reason. Now, that methodology has been, at this point, discarded, but there are two relevant points to be made about it. The first is that the judge made a basic salutary point, which we will respectfully endorse, that in all these FRAND cases, it's necessary for the court to work off the specific evidence and arguments presented in the proceedings to hand. There's a sort of Hollington and Hewthorne angle, not to treat as points of law findings from earlier cases where you have different parties, different arguments, and different evidence. And on page 299 of the judgment, at the foot of the page, paragraph 144b, the judge makes the point about Apple, the litigant in this case. Apple was not party to the Unwired Planet litigation. Many of the arguments advanced before me in this trial were never articulated before Mr. Justice Birss. The evidence I've heard was not the evidence heard by Mr. Justice Birss, and so forth. All of that is unexceptionable. And my wider comment is this. This is a rapidly developing field of the law, as I am now discovering. And in my submission, it's right to be cautious about treating the reasoning that was given in other contexts, where particular issues were not before a court, as if they are universal, or as if it were statutory. Because the nature of the evidence that was presented to the judge in this case about how the industry works, which rightly influenced and shaped his approach to the issues, and all the evidence in support of it, that was, as far as we can discern, in certain respects different from that in the previous cases which this court has recently considered, and where the different approach to the comparables exercise was adopted. And I'll come to that in a moment. But my second point is that although in this appeal, Optis is not pursuing what was then its primary case on the approach to valuing the portfolio, the scaling from Unwild Planet, the thrust of the reformulated primary case now as it is in this appeal is first that there is a conventional, use Optis's term, well-established approach to valuation, namely unpacking and scaling from a specific number of comparables, which, according to the case in ground 2, amounts to a legal error for the trial court to have departed from. And I've taken you, I won't take you back now to their skeleton from paragraph 88 and 90 and so forth, where they do this. Our submission is that the notion that there is a single correct methodology in law is misconceived, and the submission made to this court in that regard involves a similar type of error as that which infected Optis's primary case on approach to valuation below, which was the scaling from Unwild Planet. Our point is the trite one, that the circumstances of each new major case do throw up new insights and may involve the presentation of evidence that was not available in the earlier cases.
Well, I'm struggling to understand that submission. I fully take the point that evidence can differ between different cases, and you say the evidence in this case was different. Fine, I'm sure it was. What's that going to do with the principles that one is applying? Because we shouldn't forget that comparables methodology doesn't originate, even in the patent context, in FRAN cases. It was established decades ago, if not longer.
Yeah.
And it's not unique to patent cases either.
Yes.
It goes across the whole of intellectual property, and indeed, as my Lord Justice Newey has pointed out earlier in this hearing, it's applied in other fields too.
Yes. Yes. My Lord, I don't demur from any of that. What I'm going to focus on is your use of the phrase, the comparables approach. Because my submission is going to be that what the judge did here, where he considered a spread of real-world examples and used them in a particular way, was a species of comparables approach. Mr. Speck is using the term the comparables approach in the narrower sense in which that the exercise was performed in the other cases. It's my first observation. And my second is this, which I'm coming onto in just a moment. It was a feature of this case, which I'm just about to explain, perhaps because it was Apple, which was the party subject to the litigation. It's licensed to half the stack. The amounts of money involved are essentially tremendous. That one of the considerations in this field, which within ETSI, the European Commission coming to, assume particular importance, is bearing in mind not just how does this comparable relate to another comparable somewhere else, and look at bilaterally the differences in the circumstances. There is a particular need, which at least was part of the evidence in this case, to taking the wider view and considering the aggregate royalty burden. And I accept that in other comparables cases, perhaps, many of them, there is such a feature. But here, it's something which the regulatory authorities and in the industry discussions is of acute importance. And that was evidence that was presented to this judge in different ways. It was in the Apple methodology, it was in the factual evidence, it was in the expert evidence, and it did influence the approach he took, which was not to treat the top-down approach in the way that it had been dealt with in Unwild Planet, for example, with public statements that people had come out with and use that as a cross-check. It was to take these examples of licenses, other licenses granted, including by major set licensors, and ask oneself, as Apple does, because the evidence was this is its internal methodology, what does this mean for how much I'm paying for the whole thing, for access to the standard? And the point I'll develop, if I may, in a moment, subject to time, I've only got a few moments, is also putting that in the context of Apple's wider business, because evidence of that was also before the court and it's recorded in the judgment, because Apple is not just making brick phones, these are multi-function devices, and there's all sorts of innovations and costs that need to be accounted for, and the singular focus on this cellular stack can lead to a problem. So that's what I'm saying. It was a particular feature of this evidence in this case. But before I turn to that, and I'm going to do so in a moment, if I may step back and make a submission related to what I've now learned as being the flow of the case developments in this field, which seem to have been extraordinarily rapid. Panasonic and Xiaomi, which my lord referred to yesterday, that serves as a strong illustration of the point, as does the Motorola and Ericsson case decided in the autumn last year. And what caught our eye was that in Panasonic, this court explained that until recently, and I'm paraphrasing, it was perceived that the set licensors typically preferred to seek the global FRAND determinations, since the licensees had an important tactical weapon at their disposal, namely to require the patentee to sue in every relevant jurisdiction. So that's discussed in Panasonic. I need to turn it up at paragraphs 10 and 14 to 16. I'm paraphrasing the court's language. And what those decisions have revealed is that it can be a mistake to impose an assumption that the licensee has got a sort of whip hand because of the important tactical weapon and is prepared to exercise hold-out behaviour. The situation may be the reverse, that set licensors, and particularly the large ones, are well positioned to engage in hold-up tactics of the traditional kind by exerting serious pressure on even large implementers to drive up the rates, and that this is an ever-present threat in these negotiations. And my point is that, particularly against the context of those two decisions, I think there's an Amazon decision more recently, it is quite possible that in these license negotiations, the upward thrust of the threat of hold-up is more urgent and effective than the reverse thrust of a licensee threatening to litigate territory by territory. And indeed, one point that emerged from the Mr. Justice Mellor decision in IDC and Lenovo in 2023 was that the judge there said he regarded a license with Apple as an outlier, and in his words, only really helpful as indicating an upper bound.
Yeah, but he's got to be a bit careful. I mean, I don't think it really matters for the purposes of the point you're making, but for the record, since this is a public hearing,
yes,
it ought to be made clear that, as is apparent from what is said in Panasonic and Xiaomi, that is describing developments that have appeared since the decision in this case, taken together with Mr. Justice Mellor's decision.
my lord.
So you need to be careful about the time frame.
No, my lord, I accept that, and I'm grateful for that correction, which is well taken. My point is that, as a general matter, what one can get from these cases can cast a different light on the issues. And when you are approaching what the judge did here, which is the first big set of grounds of appeal, I will ask you to bear in mind the nature of the evidence that was led by the parties in this case. But to complete the point on the interdigital judgment, I will just invite the court to turn up only one reference in Mr. Justice Mellor's judgment, which is Authorities 2, tab 3, page 229. And it's this point. And again, it's paragraph 661 on this page. Due to Apple's unique status in the market, I doubt that Apple 2016 is a useful comparable. The rates derived from it may nonetheless be useful as indicating an upper bound. I doubt that Apple 2016 represents a depressed rate. Now, of course, Apple 2016 is the Interdigital 2016 case in this case. It is one and the same, comparable, that my learned friend has been telling this court should be rejected because it is a depressed rate that is the product of Apple practicing holdout successfully. We do not for one moment suggest that this finding in another case demonstrates there can't have been depressed license rates on the evidence in this case. But it does show in my submission that it is necessary for the court, particularly with that sort of finding and the issue raised by Mr. Speck before this court, to exercise real caution before applying any assumption. It's particularly relevant to the issues here because Optis's case below, which was rejected by the judge on the facts, but which in my respectful submission is being resurrected on appeal in their ground 3, is a factual question leading to the legal proposition that all Apple licenses with other set owners were unusable as comparables because they were tainted by this behaviour, the holdout behaviour, and second separate proposition, such that it produced artificially depressed rates, because that's the acid test. Optis relies in this court on selective material taken from negotiation documents. Those are the ones it deployed unsuccessfully in its closing submissions. Those were the submissions that Mr. Speck repeated to your lordships yesterday. But the judge heard intensive cross-examination of Apple's negotiator witnesses on all these negotiations. He also had evidence showing directly that the major set licensors, such as Ericsson, had in their armoury the threat of injunctive proceedings in jurisdictions across the world, and direct evidence that they were prepared to and did use hold up against Apple. And if I may, before we close, I'll just give you one final reference on that, which is a supplemental bundle 2 at tab 4. This isn't the only reference to this in the case. It's the only one in the bundles, I think. This was a letter from Apple's solicitors to the court to November 2022. So the trial's finished, judgment's pending, and it concerns this issue of the Ericsson patents and the Optis portfolio. Do you remember the issue there is that Ericsson's entering into the direct license with Apple. Go to the second page of this, page 23, and if you look at the heading near the foot, heading A, and look at the text underneath that, at the foot of the page, just look at perhaps the last sentence on the page. Apple has, in the clearest possible terms in its written and oral pleadings and briefs, stated to the Texas court it is committed to acceptance of the FRAN license terms that result from the Texas case, and that's under the heading decision to be bound by the court's determination. The footnote, despite this, Ericsson continues to seek injunctions on its patents, including SEPs around the world. So this is one of those cases where the sort of dynamic that this court has now seen.
I'm sorry, I'm lost. I'm sure it's my fault, but there was a license. So this must be referring to something else.
No, my lord, it's the timing, and it's my fault, not yours. This is this preceding the. Yeah, I mean, this preceded the entry into the license. Is that is that sort of thing. Yes. So I'm reminded there's a license that expires in the year 2022. Then before the new one is entered into, there was the...
So what you've just pointed us to is threats with regard to renewal.
Yes.
How does that affect the price paid the first time around?
My lord, it does not. I'm referring to something different, which is not the price paid first time around, but a point about the dynamics of negotiation, which turns into litigation, between SEP owners and the implementer, the licensees. And that is to say, there was a direct case here when the judge was before him considering all the evidence about whether Apple had the ability to exert the holdout behaviour that Mr. Speck referred to yesterday, and to exert that behaviour successfully so as to artificially depress the rates. He had the evidence, including a specific evidence in relation to Apple itself, of hold-up behaviour.
I'm still puzzled, even at the level of generality, and again, I may be failing to understand because it's late in the day, but it is a common complaint of SEP owners that they've been faced with implementers who've been holding out for years.
Yes.
We get this repeated. Sometimes it could be 10, 12, 14, 16 years.
Yes.
And they say, okay, we've had enough, so we start proceedings. And they get to court. And if you go through the rigmarole of a technical trial,
yes,
you have that first, and then maybe you have a FRAND determination. But how does the fact that the SEP owner eventually decides that its patience has been exhausted and that it is compelled to start seeking injunctions,
yes,
in order to bring the implementer to the table, and possibly they never do, but they have to rely on a court determination, how does that remove the holdout behaviour in the preceding decade?
Well, it comes back, my lord, to the point that I was corrected on a few moments ago. There was a previous licence until 2022. We're now in the zone of the renewal licence with Ericsson going forward. So that issue isn't a point. What you saw on the document I just showed you was Apple saying, we want a global FRAND determination, in that case in Texas. And you see the person on the other side of the table responding with the preliminary injunctions in Colombia and Brazil and so forth, major jurisdictions which hurt the implementer. All this is doing, therefore, is showing that in these cases, that dynamic, as these courts come to learn more about how the industry works.
On one view, and that's not necessarily saying it's correct,
yes,
one reading of it is that you have parties who, as is not untypical in these scenarios,
yes,
change positions. At an earlier point in time, one party is saying, we really want a global determination of FRAND, and the other party says, no, we want litigation, leading to injunctions or refusal. And then at another point in time, you find that those same parties have reversed their positions.
Yes.
One of them is now, the other one is now saying, we want global determination of FRAND, and the party that formerly wanted that has suddenly decided, no, that's not such a good idea. And it's all down to court decisions as to how much.
My lord, you're right. Absolutely. I've now seen this too, that in these cases, people can switch decisions, and I believe it's what part of your judgment, perhaps in Panasonic,
yes,
where you make that very point.
Yes.
I'm not demurring from that, but what I am saying is that this draws attention to, when you're considering in your own minds the evidence that was led by the judge in relation to hold out by Apple in this particular case, that on the other side of the table, the counterparties have got an arsenal of weapons of their own and are prepared to use them. My lord, I note the time.
So we'll sit at 10 tomorrow, as
You have to finish
I
at
mentioned
3.
earlier in the week. In order to make up the lost time, we'll have a 3/4 of an hour lunch rather than a 1 hour lunch. I mentioned earlier in the week that we might then sit on Monday at 10 o'clock to make up the remainder of the time, and I suspect that's a good idea, isn't it?
My lord, I'd be grateful, yes. I do propose to pick up the pace.
You're always dependent to an extent, Mr. Turner, on what questions we ask.
No, I understand that, and I'm not merely sucking up when I say that we welcome the questions. The reason is because it enables one to better get one point across. And so I wouldn't want to stop that and just say, can the court please be quiet while I talk for half a day or anything of that kind. However, I shall pick up the pace.
So we'll start at 10 tomorrow and we'll start at 10 on Monday as well.